Hello, everybody. I will be the moderator of this show, so I'm going to welcome the guests on stage now. Unfortunately, one of our guests hasn't arrived yet, if I understand. It's Madame Weber. She might come later. I hope she's fine. So please be seated. Okay, just as a very short introduction, this is how this roundtable is supposed to go. First, the guests will have a brief introduction about this topic, and after that we'll start a brief discussion, and eventually you will have the floor for a couple of questions if you like. So, our guests are, you probably know them all, Madame Viviane Reding. She's Member of Parliament for the Christian Social People's Party of Luxembourg and for the EVP, and she is former Vice President of the European Commission. Thank you for being here. And we have Mark Hübsch from the Ministry of Foreign Affairs. He's been very close with the TTIP during the presidency. He will be allowed to explain how. And we have Mr. Colin Brown from the European Commission, who is in charge of this topic. Thank you for being here. And I would like to start with you, Madame Reding. Expectations and challenges of TTIP. Please, the floor is yours.
Ladies and gentlemen, good afternoon. I might try to answer as a starter to three questions: why, how, and what. The first one, why? By 2050, the European Union will be 7% of the world's population. That's down from 20% in 1950. In GDP questions will be up to 15%. That is down from 40% some decades ago. We are the largest economy now. We won't be at that time. We might be third at the best. So when you negotiate, you never do it when you are feeble. You always do it when you are strong. And so if we wait, it will be too late to shape state-of-the-art international rules. The time for acting is now if we want to be standard makers and not standard takers. Now, you can like it or not, but globalization, servicification, and digitalization are a fact, and we need to shape them before they shape us. And that's a very big danger. So just to give you an idea about what is the EU's trade policy. It has reached an unprecedented scale. If the ongoing negotiations, and you know it is the Commission which has the competence to lead the negotiations, if the ongoing negotiations come to conclusion, 2/3 of our trade volume would be covered worldwide. It is 1/4 just now. So the ongoing load is rather enormous. But what is enormous also is the opposition against trade. So why is it so? In general, people lack trust against three players: our partners, our negotiators, and our controllers. And that makes it difficult, because that's all the players. Well, here in Luxembourg, and the minister has underlined it, 11,000 people have signed a petition against TTIP, and you have a position which is a horizontal one. It covers all parts of society. And when I listen to these people, what they tell me, and when they explain their worries, I must say they are right. Because if what they think will happen would happen, it would be a catastrophe. Which means what? Which means that simply we have not done our work in explaining what is at stake. People have the feeling that we are negotiating, for instance, a precaution principle. That you cannot negotiate a precaution principle. Or you have it or you don't have it. But you cannot have half of it. And so people they have the right feeling that we go to the wrong direction because we have never told them what the direction is, and we have never told them that the old style of trade agreements, which were about tariffs or non-tariffs, are gone now, and now it is about standards. And so who is caring for the standards? The controller does, the European Parliament. And the European Parliament has a decisive role because in the end, the Parliament can say yes or no to the results of an agreement. That is, of course, a silver bullet. But before that, it de facto sits on the negotiation table because it controls what the chief negotiator is doing. Before and after each round of negotiation, the negotiator comes to the Parliament, tells everyone we have access to all the documents. I know you hear the contrary, but it is simply not true. And by the resolution which the Parliament adopts, the Parliament says very clearly, here are the red lines. And if this is in the text, we are certainly not going to vote in a positive way. So the resolution adopted for TTIP in July this year was very clear on the right to regulate, on the public services to be excluded, on cultural diversity to be respected, on our standards to be negotiated to the top and not to the bottom. We support a better international regulation, but we reject a lowering of European regulations. And one of the elements of the resolution was clearly the question of private justice. And you can imagine that me, as former commissioner for justice, I have a very clear position on this. By the way, I have expressed it regularly, even before the Parliament's resolution. Independent, reliable public courts. That is what we need. We need, and of course, investors need protection, and they need judicial remedies, and if they are treated unfairly. But we need a comprehensive reform of the private justice system, so that justice and trade can reinforce themselves and not oppose themselves. On the basis of the Parliament's resolution, the Commission has presented a blueprint which takes up important innovations. First, all the transparency questions, a binding code of conduct, the clarification of the definition of the standards, but most of all, a very explicit recognition of the right to regulate. And I would like to say to the Luxembourgers in the room, that does not only mean to regulate at the European level or at the national level, that means also regulating at the local level, because I hear a lot of mayors and presidents of regions who have a big problem. And then for TTIP, a list of 15 qualified, publicly appointed and publicly remunerated independent judges, a new name, investment court system, and an appeal body conducive to create jurisprudence, which is of utmost importance because we have no jurisprudence at that moment. For me, this is an important first step, but only a first step, because what I want in the end is a permanent international investment court which applies a common set of international rules. In one sentence, one world, one law, one court. That is what we want. That is what we want. And what is now on the table from the European side is a first step, a first right important step towards this internationalization of the court. Well, that is what Europeans seem to want. Do the Americans want it? Well, the first round of negotiation will be in February. The Americans just have finished their TPP. They have 40% of world trade under TPP, and they could say, we don't care what you want. We have the power now in order to apply our rules. But that is exactly what is at stake in this moment, and I think it is a very good movement that the Commission has managed in the newly agreed EU-Vietnam trade agreement to have the reform, the investment court system to reform already included. So the Commission has shown by this that it goes to the right direction. We will have to face a very big opposition, not only with our American counterparts and our negotiators in this field, but also inside Europe. I just would very shortly say that Business Europe, the umbrella organization of the business organizations, is fiercely opposing the new system, and that you hear more and more, mainly out of Germany, that to create a court is not a good idea. So we are not at the end of our game, we are at the beginning of our game, but if you know where you want to go, you will win, whatever time it takes.
Thank you very much, Madam Reding, for these first remarks, and I will just follow up with you, Mr. Hübsch, then, just to go this way, and I'm going to mention your exact position. You are Deputy Director, right, for International Economic Relations and European Affairs for the Government of Luxembourg. Please, your opening remarks.
Thank you very much, Mr. Allen, and good afternoon, ladies and gentlemen. Yes, indeed, I'm in charge at the Ministry of the so-called T-files, which means that I'm in charge of TTIP, CETA, TISA, and whatever trade agreement is currently negotiated. So I got all the so-called toxic files in the view of some of our guests. Well, if you ask me what are the challenges and what are the expectations of the TTIP negotiations, then I would answer from my perspective, from the perspective of the presidency, but also from the perspective of somebody who followed these negotiations for, let's say, the last 12 months, that the biggest overall challenge was perhaps the fact that the whole public debate was focused quite heavily on the governance of these negotiations rather than the content. It was mainly about who is involved, at what stage, to what extent in these negotiations. But the content of the future agreement was not dealt with in the same manner, which to some extent is also quite understandable, because at this point of time, or a couple of months ago, there was not much content that, and at least in terms of intermediate results, that we could talk about. But take, for example, the very intense debate about transparency. Again, this was mainly about governance. Who has access to what kind of documents, in what circumstances, and where, for example, under which conditions. And, well, fortunately enough, we have found solutions and answers to almost all of the questions related to transparency. And as Madame Reding just told us, all the MEPs, for example, have access to all confidential documents. And the modalities for access, for granting access to these documents to the national members of parliaments is also almost concluded. There was perhaps one notable exception to this overall predominance of governance over content, and that was, of course, the issue of investment protection. And for us, as the presidency, it was, of course, a major challenge, because at some point of time during the last, I would say this year, at some point of time, we've got the impression that the member states are negotiating among themselves about a perfect system of an investment protection, but at some point of time, they start losing the view that we still have to conduct a negotiation with the United States on this. So, of course, we can work out a perfect system that suits us very well. But if our American friends will tell us this is not what we want, we have to start all over again. So it's better to find I would say, an agreement, an internal agreement amongst member states to finalize a proposal where everybody can agree upon, and then hand it over to our American friends and see what will be their direction. Madame Reding already described the whole proposal in all the details, and it has been handed over.
Yes.
I'm looking to,
yeah.
Of course. Well, and what I would also add to this is that as a presidency, we had quite some influence in elaborating this proposal, because it was already at the beginning of this year, in January, that Minister Asselborn, together with a few of his colleagues, and of course the members of the European Parliament and the Commission, worked out some kind of, let's say, political position paper to give the Commission some kind of guidance where such a proposal should, or in what direction such a proposal should go. And if I should talking now about the expectations, well, again, the answer will be fairly simple. We hope to get the whole process moving forward, which means we need to have some kind of intermediate result, or at least we want to have a progress in the field of, I would say, public procurement, in the field, of course, of sustainable development. But again, I would say that the masterpiece of a future agreement will be the chapter or the dispositions on regulatory cooperation. It is in there where the greatest benefits, be it in economic terms, or be it in terms or from a geopolitical perspective, where the greatest benefits of such an agreement will be, because it's at the end it's either China or India who will write the rules, or it's Europe together with the United States. I think that's all for the moment.
Thank you, Mr. Hübsch, and welcome, Madame Blanche-Weber. I'm glad you made it. I'm glad you're here. I would like to follow up with you, if you like, to make your first introductory statements about this roundtable, which is, of course, as we just mentioned, expectations and challenges of TTIP.
Apparemment, j'étais 2 minutes en retard, je m'excuse, mais j'ai entendu Madame Reding du fond de la salle. Elle m'a dit que je pourrais parler français ou en anglais, alors je préfère le français, si ça va.
Okay. Yeah.
Je suis très honnête, je suis toujours très émotionnelle dans ce dossier et je l'accepte. Vous savez, moi aussi, je suis de très près le dossier. Je suis une des initiatrices de la pétition européenne qui a collecté 3 millions de signatures contre le TTIP dans une année. C'est gigantesque. C'est la première fois qu'en Europe cela a eu lieu et il faut l'accepter. Et j'espère que les responsables politiques le voient, que 3 millions d'habitants se sont prononcés contre. Moi, je crains honnêtement que les responsables européens perdent toute relation avec la population et essayent de la surmonter avec des arguments, je ne sais pas comment les qualifier, mais même si les responsables politiques auraient raison avec le TTIP, il y a un très grand problème que la population ne suit plus. Si dans le futur, ce sont les partis de droite qui gagneront, c'est parce qu'il y a un clivage gigantesque entre les acteurs politiques et la population. Mais en fait, moi aussi, je suis convaincue que la population, dans ces temps-ci, a raison. Moi, je suis toujours dans la position de devoir discuter pourquoi je suis contre TTIP. Mais en fait, moi, personnellement, je crois que ceux qui sont pour TTIP ou CETA devraient avancer des arguments beaucoup plus détaillés pourquoi ils sont pour TTIP ou CETA. Il faut noter que des chiffres publiés, quelles sont les estimations, qu'est-ce qui nous apporte le TTIP du point de vue économique, etc., et ont partiellement été retirés, ne sont plus sur les pages officielles de la Commission européenne parce qu'ils sont contestés, hautement contestés. Le chiffre sur lequel on se base actuellement, c'est qu'on aura une croissance par année de 0,05% de PIB pendant une année avec TTIP et CETA. Ce sont les chiffres officiels. 0,05%. Je ne peux même pas le dire, c'est aberrant. Il y a un responsable qui a dit le temps, pendant une semaine, influence davantage la croissance économique que TTIP et CETA, selon les dires des responsables politiques. En fait, je trouve que les argumentations pro ne tiennent pas la route, qu'il faut les détailler davantage. Moi, j'accepte plus les slogans, c'est tout bien nous et la Chine, nous et l'Europe ou l'Amérique et la Chine. J'accepte plus ces arguments, ils sont pour moi beaucoup trop sommaires. Mais bon, si on entre dans ces arguments, le deuxième, c'est que toujours on nous dit on garde ce qu'on a actuellement, on ne mettra pas en cause nos valeurs et on ne mettra pas en cause nos normes. Or, le fait, et ce que M. Hubsch a dit, c'est la Regulatory Cooperation qui domine, et on sait très bien qu'il a été agréé à certains standstill, c'est-à-dire pour développer bon nombre de normes sociales, écologiques, etc., on doit être d'accord entre nous tous. C'est un petit peu résumé sommairement, mais bon, on ne peut pas entrer dans les détails. En fait, ce que ça veut dire, nous, personnellement, je n'estime pas que, par exemple, l'Amérique a souvent de plus mauvaises valeurs écologiques. Non, je ne dirais jamais. Je ne dirais jamais que l'Europe est beaucoup mieux que l'Amérique. Moi, je dis qu'on a tous les deux besoin d'avancer. On a les besoins d'avancer au niveau des pesticides, de la protection du climat, de la diversité, de la santé, de la protection du consommateur, etc. On connaît tous les problèmes qu'on a actuellement. Et si dans le futur, on doit être d'accord entre tous les pays européens et l'Amérique pour avancer dans ces détails, eh bien, parti pour le bonheur. Pesticides. Nous, on avait le courage d'interdire les pesticides, certains pesticides, notamment en relation avec l'accident qu'on a eu l'année passée concernant la qualité de l'eau au nord du pays. On ne sait actuellement pas qu'est-ce qui va se passer si un pays membre de l'Europe veut interdire un pesticide et si un investisseur quelconque ne le trouve pas correct ou si un membre de l'Union européenne ou de l'Amérique ne le trouve pas correct. On est à un niveau de stand-still. Et ce qui avance doit être accordé par la coopération régulatoire, comme M. Hubsch l'a dit. Et là, on doit consulter maintenant les détails qui ne sont pas toujours très clairs et pas affinés dans les derniers détails. Ça, je l'accepte. Mais ce qu'on lit actuellement, c'est que le développement, tout ce qui est dans la logique de TTIP et CETA peut se faire par des administrateurs, par des personnes non élues. Ça ne doit plus passer par les parlements nationaux et par le Parlement européen. L'évolution de certains standards, l'évolution, dans quel sens que ce soit, se fait par des fonctionnaires et ne passe plus par les parlements nationaux ou par le Parlement européen. C'est marqué dans CETA et c'est marqué dans les dossiers qu'on peut consulter sur TTIP. C'est un dépassement de nos valeurs démocratiques à outrance, vraiment à outrance. On a combattu durant des décennies et des centaines d'années pour avoir un état de droit où le citoyen a le droit de voter ses parlementaires qui, eux, ont le droit de décider. Avec CETA et TTIP, leur compétence serait réduite à un niveau que moi, je ne peux plus soutenir en tant que luxembourgeoise et européenne. Ce ne serait plus mon Europe si mes députés, mon gouvernement et les parlements européens perdraient à ce titre les moyens. Et c'est arrêté dans CETA. Je crois que, vu le temps de parole que j'ai, je vais m'arrêter un petit peu. On peut aller dans les détails, mais ce que je veux dire aussi, c'est que On nous dit toujours, bon, qu'est-ce que vous avancez là en tant que personne qui n'accepte pas CETA et TTIP? Les résultats des négociations ne sont pas connus. Mais bien si, ils sont connus. C'est une des raisons que j'avais 2 minutes de retard. J'étais en train d'imprimer une nouvelle fois CETA. CETA est connu, le résultat est connu, et CETA est le prédécesseur de TTIP. On le sait tous. Et si CETA passe, les droits sont validés pour toutes les entreprises établies au Canada. Il ne faut pas se faire idée, même si une modalité spécifique correspondrait plus à une entreprise au niveau du Canada qu'au niveau de l'Amérique. Il irait en Canada, une grande entreprise. Et j'étais en train d'imprimer CETA, mais mon imprimante n'a pas réussi le coup. C'est un document comme ça, plus de 1000 pages, et tout est arrêté. Et si quelqu'un nous dit que ce n'est pas connu, ce qui nous attend, ce n'est pas vrai. La seule chose qui est vraie, c'est que c'est un document de merde de plus de 1000 pages, un document juridique de 1000 pages. Monsieur Hansen, vous discutez de 20 pages de législation, et on sait bien quel travail ça est, et on a un débat démocratique sur ces 20 pages. On n'est pas toujours d'accord, c'est ça la démocratie vivante. Comment on veut discuter 1000 pages qui entrent dans tous les domaines de notre vie sociétaire? Et on avait M. Baud au Luxembourg, on ne parle plus de tarifs. On sait très bien qu'au niveau des tarifs, on peut faire des ajustements, mais ce n'est pas les tarifs qui sont des problèmes. On ne parle pas des clignotants. On n'a pas de problème à régulariser les clignotants, ce n'est pas le problème. Mais on entre dans les normes qui régularisent notre vie journalière. Santé, protection du consommateur, écologie, normes sociales, etc. Et c'est ça le problème. Et si vous me dites qui va pouvoir discuter démocratiquement sur 1000 pages de textes juridiques entrant dans tous les domaines de notre société, je m'en doute. Et M. Hasselborn nous-même a dit...
justement de discuter. We will try to go into these details. I understand where you come from.
But it's from page per day. Yeah.
Thousands of pages. It's going to be really hard to go over these, all of them. But this was just the first round of introduction. If you allow me, I'm sorry, but I would love to give the floor to Mr. Colin Brown. I will just mention his exact position. As it was told to me, you're Deputy Head of Unit Dispute Settlement and Legal Aspects of Trade Policy at the European Commission. And without too much maybe reacting already to the criticism you heard, I'm sure that by responding to expectations and challenges, this will already maybe provide some answers to what you just said, Madame Weber. So, Mr. Brown, the floor is yours.
Okay, well, good afternoon, everybody, and thank you very much for the invitation to be here. I'd like to thank Professor Ruiz Fabri for having noticed that we held up the release of the TTIP investment text just so that the timing would be perfect for this conference. It was all been planned for a long time. I wanted to make two essentially basic points. The first is to say a few words about the expectations of TTIP. What will it bring and what are we focused on? And the second, to make a few points precisely on some of the things that Mrs. Weber has just touched upon on this issue of the right to regulate and how and what does that mean and how will that be handled. The first basic point is that in the Commission's view, the conclusion of the TTIP agreement will be hugely beneficial for the economy of the European Union. Madame explained already some of the importances, the important elements just now of how the EU in relative terms needs to engage and needs to go further in terms of liberalizing trade and making sure that its economy can grow. TTIP has a number of key elements that are being negotiated. Some of these are basic and well known, and others are more innovative and go further. And it's around a mixture of, in fact, of the ones that are already well known and the ones that are more innovative that most of the controversy arises. So what will TTIP do? TTIP will, at a basic level, seek to remove tariffs on trading goods between the EU and the US. There are a number of places where tariffs are still high, and it's valuable to remove them. It will remove barriers to the provision of services and to the ability to invest in the two economies. And again, that is an area where there are a number of restrictions or limitations that are in place and where value can be found. One of the key things that the EU is seeking to do is to increase the access of European Union operators to the US procurement market. And that is one of the key goals that we are seeking. There is also an important part of the TTIP which is focused on rules setting, where we are putting in place rules which to some extent exist already in one or other international agreement. And we are putting them into the context of TTIP, both because they're important on a bilateral basis, but also because they're important in terms of setting standards internationally. Intellectual property rights is one of the key areas there, where work has to be done on both sides of the Atlantic on the protection of intellectual property rights. And another similar area is the area of investment protection and investor-state dispute settlement. As many of you know, the system of investment protection, investor-state dispute settlement, is not something new that was invented for TTIP nor for CETA, the agreement with Canada. It is an existing system that has been in place for a good part of 50 years. Now, the most innovative part of TTIP, and the one where a lot of the intention focus is around the desire to cooperate on regulatory matters. I think it's important to underline what that really means. That does not mean that the EU and the US will seek to agree on the standard of protection that they're trying to pursue. In some cases that may be possible, but that is not the objective behind regulatory cooperation. The objective behind regulatory cooperation is to remove unnecessary testing, double regulation. And a good example of that, a very simple one, is the example of scallops, so of coquille Saint-Jacques. In Europe, the objective of the EU and the objective of the US in terms of trade in scallops is obvious. We want scallops that you can put on your dinner table and not fall ill because you're eating the scallops. There are two ways of testing this. You can test it by testing the scallop itself, or you can test it by testing the water around the scallop. The EU tests the water around the scallop, the US tests the scallop itself. If you're a scallop producer off the coast of France, for example, you have to do two sets of tests if you want to export your scallop to the US. The objective of TTIP is to remove things like that, where you have a double testing requirement where the objective is identical. And there are many other examples that expand into many different areas, but that is one that I've always found particularly striking and straightforward to use as an example. Now, the second point I wanted to make is that TTIP will not harm our ability to regulate, provided we're regulating in a non-discriminatory manner.
Pardon, l'interdiction des pesticides.
Oui, I'll come to that. Je vais arriver. Oui, j'arrive.
C'est discriminatoire.
Non,
si on interdit des pesticides, c'est discriminatoire.
C'est pas discriminatoire.
Mais c'est plus vivant de discuter.
Oui, non, il n'y a aucun problème. So we will not harm the ability to regulate. Now, one of the important reasons to say this is that the base we're building upon is a base that has been there for a long time. Many of the rules in the first category of rules that I was talking about on trading goods, on services and investment, on investment protection are rules which have been in existence for a long time. Many of them are developed or derived from the World Trade Organization. There are many members of the audience that know far more about the World Trade Organization than I do, but it's well known that under the World Trade Organization, each country has freedom to regulate matters in the way that it feels that it is necessary. We have also these types of rules in many existing free trade agreements that are already there. The biggest one up until now is the Korea Free Trade Agreement, which has just entered into force fully in the last few weeks. It has many of the same rules as TTIP, but doesn't cause any of the concerns that have arisen around TTIP. And to take an example of pesticides, or it could be any other issue, as long as we are regulating pesticides on a non-discriminatory basis, so a particular pesticide is regarded as being dangerous for the environment or being dangerous for health, whatever the scientific reason might be, if we decide to prohibit that pesticide for that reason, then that is something that will be perfectly consistent with TTIP. The US also regulate pesticide. They also ban pesticides in a number of circumstances, and they do not want a TTIP either that would lead to an inability for them to ban pesticides for health reasons. And the same goes for investment protection and investor-state dispute settlement. There are a number of actually quite well-known cases where chemicals have been banned, and the investor-state dispute settlement panels that are existing today have said, no, sorry, any businessman has to accept that in the natural course of business, in the natural course of regulating, states may decide to ban a particular chemical for a particular health reason. And we've gone further on this, and Madam Redding has talked about this, and so I won't go into detail, and we will talk about this in a great deal of detail in the conference tomorrow. But the new proposals on the investment system go even further in terms of ensuring that that balance is there, in terms of clarifying how these different regulations and principles would apply, how it would be clear that the prohibition of a pesticide would not be considered as expropriation or would not be considered as discriminatory, provided it is done on an even basis. And we have also done a great deal of work to make sure that the adjudicatory system not just functions properly, but is beyond any doubt that it is functioning properly and in the public interest. And I think that is the key thing to emphasize, that a lot, as with our own domestic justice systems, the people that look at how they operate need to believe that they will be objective, transparent, and fair. And in doing so, we can ensure that the results are acceptable. One final word, if I may, on transparency and democracy. The first is, this is the most transparent ever trade negotiation, for better or for worse. All of the Commission's, the EU's negotiating documents are on the Commission's website. There's an explanation of what they mean in non-legal language as well. We regularly speak, of course, to the member states. The Parliament will need to give its consent, as will the Council, the member states, and the Parliament. And there's one important point that I also already want to pick up, and I think Ms. Fabri is touching on this. In these agreements, there's lots of references to committees, because the committees are there to administer the agreement, to manage the agreement. What is important to bear in mind is the way that the positions are decided for the positions taken in those committees. It is not the Commission, and it is not myself or my colleagues that arrive at the Commission these committees and say, well, we think we want to do X, Y, or Z. The people that speak in these committees have the position that they take is one that will have to have been approved by at the minimum the Council, so by a qualified majority of the member states, and very often also by the European Parliament. So it is not the case that any important decisions under these agreements can be taken by administrators without democratic scrutiny. I think it's important to insist on that point and to end. Thank you very much on that particular point.
Thank you, Mr. Brown, and thank you for these 4 introductory statements. And before I can get my head around all that's been said now, I would like to kick off this discussion maybe with something you just said, Mr. Brown, about the scalps. I read the same thing about the oysters, and that seems to be a way of the European Commission of trying to communicate with the people and their concerns. But now when you say that you want to get rid of double testing, the big question is, what testing would be kept for what products? And I think that is maybe what can make some concern for people outside.
Can I respond
Of course.
directly to that? Yeah. The idea is very simple. It is if where the EU and the US agree on the objective being pursued. And in that example, the objective is the protection of human health. And where we agree that the testing methods are effective, then one or other of the testing methods is sufficient. So it might be for the US will accept that the European testing methods are fine. And the US will accept that the European testing methods are fine without requiring the same test to be done twice. So that's the basic idea of what we're trying to get to in terms of regulatory cooperation. That double testing where it gets to the same result will not be required. And it won't be that you will have to choose either the US testing or the EU. It will be that the domestic testing will be sufficient.
Madam Reding, just before Madam Weber said that there's so many pages, do you think that, as you said, the European Parliament is kind of the watchdog over these negotiations? You will be able to go through all these technicalities and texts that are being negotiated right now?
Well, if you are a responsible politician, you have to. Huh? I am the rapporteur for the new treaty on services, the follow-up of GATS, and I'm just negotiating 600 amendments in the committee. I am in and bring them down to 20 or 30 amendments which are compromises. So, of course, I must not only go through 600 amendments, but also to what they mean, and in order to bring them together. I am one of those few politicians who also went to the reading room and has read these very boring papers, I can tell you. Most of it is terribly boring.
Which one? Huh? About services or about the TTIP?
No, about TTIP. Yes. I want to read this. And at any rate, all the papers which have been negotiated are on, and it has been said very clearly, on the internet portal of the European Commission. Mm-hmm. Do you know how many people visited that internet portal?
I hope not 3. That would be the 3 of us.
20,000.
Oh, that's a little
which
bit
means nothing. Yeah. Because actually, the public debate is not about content; it is about slogans. And so, very often, if you would go to the content, the slogans would be in difficulty. So it's better not to go to the content. I can tell you also that the American papers, which we do not have such an easy, we cannot so easily reach them. Well, they have all been hacked. So we have them too. So somebody who would like to see what's going on really can do it, but it needs a lot of work. It's a lot of technical stuff. There is also a lot of political stuff. And there are questions, the ones which we have been told now are easy to be solved. There are questions which are more difficult to be solved. And that is when there is a real opposition in thinking between the two parts of the negotiations. Precautionary principle, for instance. In Europe, you take a precaution that nothing happens. In the United States, you leave it happen, and if something happens, then you react. So there, on this kind of elements, it will be extraordinarily difficult to arrive to a conclusion. But on the more technical questions about the mirrors in the cars or these kinds of things, it will be a good faith to arrive to a conclusion. So those are rather easy. There are some difficult ones to stay on. And then in the end, it is a big power game. Because if you look what the United States have done now with having 40% of the world trade with their TPP agreement, the Pacific Rim, and trying to corner the Chinese, not to have them in. The Europeans, for instance, would like to take in the Chinese in negotiations, because we do believe it's better to have them on the table and to pacify questions, to regulate questions, rather than to have them in a Wild West manner outside. So those are, I believe, the real questions which have to be asked, and those are questions simply of political responsibility. You can do polemics, easy. Or you can go ahead and in a responsible way try to solve problems. And I think that is what we have been elected for, and that is what we should do. And that is also why the European Parliament has made these red lines very clear. So if the red lines are not taken serious by the negotiators, it's going to be a no. That's easy as that. But you cannot put a red line also on the mirrors of a car. That would be ridiculous. But to put a red line on principles, on very important elements, for instance, the right to regulate, the political right to regulate. What Madame was speaking before, that is comitology. Comitology, we have it everywhere. We have it also in European law. You have it also in national law. That is something, is it good, is it bad? How can you control comitology? That has nothing to do specifically with foreign trade. It is something which is everywhere in our political decision-making at national, European, and international level. So in order to change comitology, and we have very often problems with comitology on our European law, for instance, well, then you have to make a major reform of the way political decisions are being put into practice, and how this being put into practice is then again controlled by politicians. So that is a huge debate, but has nothing to do specifically with foreign trade.
Madame Weber, I've seen you disagree a couple of times now after what's been said, so did you want to react on something particular?
Bon, j'ai noté que pourquoi on est contre TTIP, pour TTIP, parce que c'est bien pour l'économie. Vous n'êtes pas allé dans le fond des arguments. Qu'est-ce que ça rapporte à notre économie? Encore aujourd'hui, il y a 200 PME allemandes qui ont publié un statement pourquoi ils sont contre TTIP. Parce qu'en tant que PME, ils craignent des pertes par TTIP. Il y a bon nombre de PME dans toute l'Europe qui sont contre le projet, pour ne citer que les 0,05% de croissance économique. Vous n'êtes pas, dans votre petit speech, vous n'avez pas le temps, mais quand même, c'est resté à la surface de nouveau. On en a besoin pour développer notre économie. Il n'y a pas de preuves, il n'y a pas de documents qui reflètent ou qui puissent démontrer cette thèse. Et si on parle polémique, moi je trouve qu'on devrait faire un débat honnête à qui rapporte TTIP quelque chose et qui va être perdant. Et ce sont les PME.
Est-ce que c'est possible de...
Mais c'est pas notre... Moi je crains que c'est très difficilement possible, mais c'est pour ça que je dis, OK, si on n'a pas de preuves, pourquoi mettre sur table tout bon nombre de nos valeurs, notre système juridique, démocratique, nos normes écologiques, sociétales, etc., si on n'est pas sûr qu'on a un certain gain. On doit parler relations. On n'a pas d'assurance qu'on aura des avantages économiques. Il n'y a pas de preuve, je peux le dire 1000 fois, même de la Commission européenne ne publie plus de tels documents. Monsieur Lange, le responsable de la résolution invoquée plusieurs fois par Madame Reding, a dit dans un débat public, je ne publie plus de chiffres, je ne peux pas publier de chiffres, ce qu'on va avoir comme recette pour l'économie et au niveau de place de travail. Un des points.
If we may stay with this point first, then we can go on with another criticism you just said. Mr. Hübsch, you wanted to react on what Madame Weber just said about the small and medium enterprises.
Yes, exactly. Maybe a few words on, let's say, the economic rationale about and behind TTIP, because we talked about scallops and oysters and pesticides. So at the end, we risk to getting sick about all the details. And let's not forget the broader picture. And if you want to understand what the economic rationale is behind TTIP, then it's quite simple. You have to remind 3 numbers. And these 3 numbers are 5, 10, and 20. Why 5, 10, and 20? Well, 5 is 5%. It's the average tariff rate between the United States and the European Union. You are completely right, it's quite low, but it's an average tariff. It doesn't mean that you have peak tariffs in specific sectors like dairy, like textiles, and other sectors. And we should not forget that even if an average tariff or an applied tariff is low, and if it is applied to a huge volume of trade, then of course the possible benefits of lowering this tariff is again quite important.
Mais pardon, même si c'est pas sympa, même Monsieur Hasselborn, les responsables de la Commission disent on ne fait pas TTIP pour les tarifs.
That was my first point, not my last. I talked
on
about
a
3 numbers.
c'est pour les tarifs et c'est pas pour la tarif. On doit faire un discours
No, but
honnête.
that's not what I said. You have to listen.
Vous le faites au premier point. Vous le faites au premier point
Yes,
parce que c'est le point que chacun
5
accepte.
comes before 10.
Chacun accepte qu'on peut adopter les tarifs.
That's not more than that.
Let's see what Mr. Herbst has to say, and I will of course try to hand over again if you like.
So after 5 comes 10. 10% is the cost of border administration, which means if you want to clear your product by entering a new market, you have to do some paperwork and so on. And that cost represents, all in all, on average, about 10% of the value of your product or your service. And of course, TTIP wants to streamline these procedures. It's about what we call trade facilitation. Or here in Luxembourg, it's about simplification administrative. Mm-hmm. Is it scary? Maybe, maybe not. So much about the 10%. But now comes the 20%. And 20%, this is where the regulator cooperation stands in. 20% is the average cost that you have to bear if you have to cope with different regulations on the 2 sides of 2 markets. And of course, it will be the small and medium enterprises who will benefit more of this regulatory cooperation than the large enterprises. Why? Because this 20% average cost is a fixed cost. So if, as a small producer, let's imagine that you are a very small producer. You are just selling 1 single car for €1,000 and you want to sell it to the United States. Then, of course, if you don't want to make a loss, you have to sell it at least at €1,200 because you have to add 20% of different regulations you have to cope with. But if you are selling, for example, 10 cars, then of course you can sell each of your car at the price tag of €1,020. You see the difference, €1,200, €1,020. It's of course the small and the very small producer and the very small enterprises that can potentially benefit most of TTIP.
If I may, just one point. Many people might believe that the TTIP is not going to benefit small and medium enterprise because they don't do overseas commerce many times. So maybe that explains why it will, at the end of the day, benefit more. And I think a part of the question of Madame Weber, which has also been documented in an interview with the former Commissioner Karel de Gucht, is that indeed it would only add 0.05% of GDP every year, which does not sound like a lot when you compare it to other situations that could provide more growth. So can you please go on with talking about that figure, 0.05% of GDP? Is that still what's on the table, or how much would it bring? And also the question about small and medium enterprises, if all of them can really benefit from this.
Yes, of course. I mean, we know the result of this study. It's no longer on the table as far as I know, but maybe Colin could add something to that. But at the end of the day, I mean, these studies are based on scenarios. What you could get out of a TTIP if you, for example, can eliminate all differences between all differences in the field of regulations, or if you have a complete phasing out of the remaining tariffs, and so on and so on. So you have some basic assessments to conduct these studies, and then of course you have some hypothetical results. So in my view, we should first wait, or at least have a clearer view on what will be in the future agreement, and then we can always do some impact assessment, and we will see that the numbers will be quite different from the ones that you have stated. But maybe
Mr. Brown, you wanted to
yeah, I think
add something.
Fairly briefly, I think, and essentially to make 2 points. One is that if we look at previous agreements, the Korea Free Trade Agreement is the largest FTA that the EU has concluded up until now. We see that the free trade agreement brings about an increase in trade in goods, an increase in trade in services, and an increase in investment. The statistics from the first few years of application of the Korea FTA are very positive in this sense. Now, TTIP is larger, will be more ambitious, so we can expect, and we'll need to see, these are indeed projections, but we'll need to see how that plays out, but we can expect similar types of results. The second point is that I think it's, with all due respect to Madam Weber, I don't think it's correct to put on the one hand the level of growth and on the other hand the undermining of democracy or phrases to that effect. Yes, the objective of TTIP is to bring about an increase in growth, but it will not and does not undermine democracy. It does not undermine the ability of EU member states from central government level right down to local government level to regulate when they see the need to do so. So it is not, that's not the cost-benefit analysis, with all due respect, that we think is the appropriate cost-benefit analysis. The appropriate cost-benefit analysis is what happens if we don't do this. And we see that there are advantages clearly in doing this.
If I may, I might want to talk about the main subject of tomorrow as well, which is investor protection or dispute settlement, and I think it's been touched a little bit already during these discussions. Madam Reding, are you familiar with, I mean, perhaps I will start from the bottom again, like the concern of people who are not familiar with TTIP or with negotiations, fear when they read headlines of Chevron versus Ecuador, of Veolia against Egypt, and Vatter, I forgot the name of that Swedish one. So I'm sure you're all familiar with this more than I am. So perhaps you can explain how can you take away a concern like that from the people?
In order to tell them that we tend to replace private justice by public justice. Look, worldwide there are 3,000 agreements and with ISDS old style inside. Europe has 1,400. I mean, European countries, member states and everything, old style. So knowing that there are some problems of fairness and in these agreements, it will be very important to create a level playing field of a public justice, which is what our democracy really wants. And this is also important for the small companies because it is extraordinarily expensive to have an ISDS complaint going on. And SMEs nearly cannot play into this. I am very shocked when I read now in the press that if we go to a public justice, the ones who will have to pay would be the SMEs, because they would have to contribute to a public justice. So you understand the twisting of everything which you try to do in a positive way in the public in the end. But if you always discuss about these kinds of things, you never do. We have taken a decision, a very clear decision, and I'm very grateful that the new Commissioner for Trade is listening and tries to change the way trade has been done so far. She has gone out of the ivory tower. She has answered to the European Parliament when the Parliament, with a very huge majority, has in the resolution pleaded for public justice. A very huge majority, those who have not voted for, were the extreme right, the extreme left, and the Greens. All the others have voted for. Interesting to see also. I think we should pursue on this way. In CETA, there has already been the first level of reform of the old ISDS system, which is in the 1,400 agreement. So CETA is already a step forward. Is it enough? No. It is certainly not enough, and that is why the blueprint the Commissioner has now put on the table and handed over to the American counterparts is a very important step forward. What we have to do now, and what we try to do at the level of the European Parliament, is to speak with our counterparts in the United States. I do that rather often. I go to the Congress. I speak with the congressmen who do have these responsibilities in their hand, and I try to explain them what is the European position. I must tell you also something, that the oversight by the European Parliament is much stronger and goes much more to the details than the oversight of the Congress in the United States. They are much more superficial, and by the way, they are much more interested in the Asian Pacific Rim than they are in the European Rim. That also is something which must open red lights in our head, because that shows you where politics could go if we do not find solutions now. I do believe that if we find a solution, and we are going for this one, with the Americans, on ISDS, which will not be ISDS anymore, but the first step to an international court, that will become the gold standard in Europe. And that will be taken over by all the others also. So we got here an extraordinary responsibility to get that through. But then, of course, if we want to get that through, then we should stop to fight ourselves in Europe. Because it's not if I bang your head here on the neighbor and if he bangs my head that we have done something. We should go as the strongest economy of the world, which we still are in this generation. Next generation won't be the strongest economy in the world anymore. Europeans, I mean. This generation has to get it through now. We have to negotiate, and we have to see that we get this first step towards an international court in place. Americans don't like international courts. They have a real aversion against this, so it won't be easy. And I wish Madame Malmström very well when in February she starts with Mr. Hofmann to discuss about the blueprint. It will not be an easy one, but I am very calm for the European Parliament, because the main players in the European Parliament will be behind the Commission. And the Commission is negotiating, nobody else. So the European Parliament stands behind that, and we try to get ISDS in the reform through, because we know perfectly well where we will go. It is a very important one, and it has to do with democracy, because our democratic systems are built that we have voting, we have members of parliament, they take the political decision, they have the power of veto in our commercial agreements. So, but if you want to exercise your power of veto, you have first to study what you are vetoing on. You have to know, is this good, is this bad, can we go ahead with this? We have said very clearly, and crystal clear, none of our rules and of our values and of our standards will be negotiated down. And neither our social rules nor our environmental rules are at stake. They are simply not in discussion. So, of course, you can then go out and say everything will be eliminated, no bargaining, no social bargaining anymore, no. But simply it's not true. It is not on the table, and it won't be on the table. Would it be on the table, the Parliament would vote no. And our chief negotiator knows that. So there is a power of the elected members of Parliament. But in order to have an input and to exercise your, to have a result, you first must know. It's not enough to say something. You have to know what is in the papers, and you have to discuss on basis of the papers, and it is like this that you can impose the way Europeans want to live. I just say a last sentence, because it is also one of those easy sentences, but it's very true. On each political decision I take as an individual, and I need a lot of individuals around of me so that my political decision will become a political decision, I always think what impact this will have on my boys. Because what we do now has an impact on the next generation, and what we don't do now has an impact on the next generation. Do I want my way of life, which I think is the best in the world, the way we drink, the way we eat, the way we preserve our environment, do I want this to be preserved? If I want to have this to be preserved, then I have to be strong enough in order to build the rules which can preserve this. If I'm sitting there and say no, 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 in the end, the Chinese will come for the next generation and tell the next generation how it has to live. And this I don't want.
Let's not be too scared of the Chinese, though. But however, I would want to move on with Mr. Hubsch, because I've heard now it's been a very clear message from your point of view of the European Parliament. You are very close to what the European Council may have to add to this new paper, because it's been the 12th of November when the new paper was published. But I'm sure the Council knew before about the amendments that were gonna happen. So do you know any positions that might be tricky in Europe? Some countries who have still issues with it?
That's an easy question. Because
please say it then.
Because well, of course, I mean, within the Council, we first have to give our green light to our chief negotiator, the Commission, in order to allow them to hand over, for example, this specific paper, but also every other paper, every other position paper, to our American counterparts. And yes, we had some very open and frank discussions among ourselves within the Council. There were some member states who wanted to go faster on this specific issue, while other delegations had some concerns about one or the other detail of the proposal. But at the end of the day, we, as the presidency, we managed to keep to the calendar that we initially set out, and well, it's not a secret that the Council approved positively this proposal before it was presented to our American friends.
With no reserves, I mean, with no concerns left, everything was clear.
Everything was has been resolved before the proposal was finalized.
As for this paper now, Madame Weber, as a critic of this TTIP, but also now this specific point of a court for investors, are you reassured after what you heard now?
Non, pas du tout. Alors, nous, on apprécie les changements réalisés. Tout d'abord, on apprécie les changements réalisés. Ils sont très importants, que les juges soient nommés différemment, etc. C'est une avancée qu'on apprécie, tout d'abord. Deuxième point, mais ça ne change pas le fond du problème. Je prends seulement un exemple pour le dire, pour l'expliquer. Il y a toujours le principe de l'expropriation. qui est par exemple dans le package. Et si on a des juges neutres, disons, ils sont encore plus responsables d'interpréter la base juridique de façon correcte. Et la base juridique détermine notamment le principe de l'expropriation. Alors, qu'est-ce que ça veut dire dans mon esprit? Ça voudrait toujours dire, si on exproprie un terrain pour construire une route, je ne sais pas quoi, c'est pour moi une expropriation. Mais au sens du TTIP, expropriation, ça veut dire un manque de faire un gain. Et c'est ça, les problèmes qu'on a eu, un manque c'est une firme a la crainte ou dit à un pays ou quoi que ce soit, écoutez, vu votre législation, moi je ne peux pas faire un gain quelconque que j'estimais pouvoir faire sans votre législation. Je vais perdre de l'argent, j'ai en quelque sens une expropriation. Il a le droit de citer ce pays.
Mais Madame Weber,
Oui.
justement, ce point a été changé que maintenant, sauf for public purpose, donc un législateur, c'est ce qu'en tout cas le texte dit.
Oui.
Ça, c'est un des changements qui ont été effectués justement. Donc maintenant, quand un pays, le Luxembourg, veut maintenant implémenter des lois plus strictes, est-ce que c'est bien comme ça qu'il faut le comprendre? Si un pays membre, si c'était signé, le draft, les États-Unis, une entreprise américaine ne pourra pas attaquer le Luxembourg si on a des règles plus strictes en pesticides, parce qu'on se cache derrière, enfin on se rapporte par rapport à l'argument de on protège notre public.
Oui, on
Donc
doit
là, est-ce
maintenant.
que c'est bien ça?
Est-ce que vous demandez à lui?
Yeah, it's essentially
It's
yes.
funny to switch between two languages.
Yeah,
Yeah, I don't think you want me speaking in French with a very bad Scottish accent.
I'm sure it's fine though, but go on.
No,
c'est le
it's indeed exactly as you were explaining it, in the sense that Luxembourg may legislate to prohibit pesticide. If that simply affects a company's profits, they cannot bring a case. And that we have written black and white in Article 2 of the text proposal. What would be a problem if Luxembourg only prohibited pesticides that were produced by American companies, for example, or Chinese companies. But that's obvious, that's discrimination, and Luxembourg wouldn't legislate that way.
It goes against competition.
It goes against competition, it goes against, you wouldn't be able to do that under European law either. So that type of legislation, yes, you would get potentially into trouble. But if it was, there's a scientifically proven, or there's enough evidence, this touches back on the precautionary principle, that we have a concern that a particular pesticide may be dangerous for health.
Let me put it this way. If, for example, because Luxembourg is a small country, it comes in handy. Let's say, for example, there is a law that affects only one company because we're a small country. Let's say that's going to penalize, I say, one big company from the US. Will that be interpreted by judges as, oh, you made that law just for that company, even though you say that it's for the public?
It would have to be shown from the facts. So if you're before the Luxembourgish Parliament and there's a debate and they say, well, we're passing this law because we're unhappy with that particular company because it's American, then yes, on the basis of all the facts, that would cause a problem. But if it was, as I go back to what I said, if it was because there was a problem with the product that was being manufactured for health or environmental reasons, then that is perfectly fine.
I go back to you, Madame
Yeah,
Weber.
merci. C'est le problème, comment c'est réglé. C'est-à-dire, en droit d'entrer dans le texte juridique, et j'avoue que je ne suis pas juriste, ce serait mieux d'avoir un juriste plus neutre ici que nous quatre, qui sont tous involvés. Mais il y a déjà des juristes de certaines universités qui ont analysé les textes et qui disent tous, c'est la preuve et la relation entre l'intérêt public et l'intérêt de l'entreprise qui est en cause. Et là, ce n'est pas évident comment c'est réglé. C'est-à-dire, ce n'est pas que le pays est toujours... il doit donner la preuve et argumenter selon certains principes que sa décision était bien fondée. Et le genre, comment sont décrits, je dis, ces principes, pose des problèmes, parce que bon nombre de juristes disent la façon dont c'est décrit dans les textes, de façon juridique, donne beaucoup de problèmes au pays de pouvoir plaider pour les droits des collectivités par rapport aux droits des investisseurs. Il y a un certain, disons, Ungleichgewicht, comment on dit Ungleichgewicht, déséquilibre. c'est ça le point de départ. Comment est la relation? Le deuxième point est que, et je crois que là, le Luxembourg peut aussi se prendre par le nez, si le Luxembourg voudrait maintenant, un exemple tout bête, tout simple, interdire un produit fait par Monsanto. Est-ce que vous croyez réellement que notre pays voudrait risquer un dossier juridique au niveau international avec tous les frais y liés s'il risque d'être tiré en courroux par Monsanto? Moi, je crains, et je comprendrais bien la position du Luxembourg, que notre pays se dirait « Ah zut, je laisse les moines de ce dossier très compliqué, je ne veux pas avoir des problèmes, que Monsanto plaide un dossier contre moi. » Et il y a d'autres pays qui ont les mêmes problèmes.
Everybody understands that concern, of course. This is
Et
not,
les communes, c'est un autre
this
problème.
is not expropriation now, this is more about, I want to prohibit a
si.
product, but if you prohibit a product, of course, but then it's again, if it's for public health, I assume that the European Commission has seen some safeguards to have public health before profits.
Non,
I don't know,
Yeah.
Madame Weber. Is that the concern you have? You have a concern that a country will not be able to prohibit a product that is
pas à
unhealthy.
juste titre, que ce sera plus compliqué dans le futur
It's going to be
de
more
les
complicated.
réaliser avec tous les obstacles qui sont faits. Et si on analyse les textes, par exemple, on dit toujours que le développement durable est à la base du TTIP. Il y a certains passages qui ont été publiés en relation avec le développement durable il y a, je ne sais pas, 2 semaines, quelque chose comme ça. Ce sont des formulations assez vagues et du point de vue juridique, on ne peut guère les réclamer devant des instances juridiques. Ce sont des déclarations plutôt pour le...
I think everybody shook their heads. Who wants to react first?
Well, I would like to because it will be interesting for your debate tomorrow, that we even go a step further than the normal right to regulate. We have put also into it the principle that you can come back to a regulation you have already made. I give you a very simple example now. I don't know if from the juridical point of view it will be accurate, but look, a city has the responsibility for water. Has decided to give the management of the water to a private company, to privatize its competence. It should be allowed to come back to this. That means at a certain moment to decide, now I do not want this to be privatized anymore, I will deprivatize it. I will bring it back to the public decision making. This can be done, but of course, if the agreement, if the contract made with the company to which it was given for privatization, if the contract is broken, it is a normal way of handling the damages. That has to be handled by a court in a normal way, but the politicians should have the right to regulate, even if it is contrary to a decision which they have taken before. So, as you see, we have been really thinking a lot about also what could happen in a revirement, a political revirement, so not to be blocked into in a standstill if once you have taken a decision. So all this, and why do we need at that moment a public judge? Because we need jurisprudence. We do not have jurisprudence on these questions now, but if we want to have a fair treatment for a state, for a decision maker, for political decision making, and for an investor, well, you have also in a democracy to protect the investor, big or small, and to give this investor the possibility to fight back. But it has to be equilibrated in such a way that not, as Madame Weber fears, the investor will be right at any moment. And that is why we need to have a jurisprudence, in order that fights in one country and fights in another country will be treated in the same way.
Mr. Brown, if I understand right, you wanted to say something as well about the products being prohibited in one country, for example, or in general, if you want to. You don't have to.
I wanted to pick up on the point that Ms. Weber was making, that we talk about as regulatory chill. So the threat of Monsanto suing was the example that you were giving, but there are other examples that are out there, and there's some big important cases that are ongoing that we don't know the result of, where you get similar types of scenarios. And this is something that was a concern from the Commission for a very long time, even well before the current debate around TTIP. And the text that we have produced, the SETA text as well, tackles this in two basic ways. The first is it clarifies significantly the substantive rules, so that it's easy for Luxembourg, in this example, to say, sorry, Monsanto, there is no problem with the legislation that we're passing, because it clearly says, we can legislate, it may have an impact on your profits, but that doesn't give you the right to bring a claim. So we do it, as I said, the first way is by clarifying the rules, and these are much more clear than the existing rules. And the second thing is through the procedure. So there's not just the fact that it is a court system that we put in place, but we also have introduced rules on costs, so that if a party that wants to threaten to bring a case, threatens to bring a case and goes ahead, and it was not in the right, it doesn't have a good case, then it has to pay all of the costs. And so in this example, Monsanto would have to pay all of the costs of the Luxembourg government or the European Commission that would be involved in that particular case. And Monsanto, and the same for any company, they make calculations when they litigate. They say, if we're going to lose and we're going to end up having to pay all of these costs, we will not litigate and we will not even make the threats in the first place.
But the government
will
think it all. So the government won't make a law if it fears to have the same.
No, but that's what I said. We clarify the substantive rules and we clarify the procedural rules so that Luxembourg is more comfortable in legislating where it considers necessary for health or social, whatever reason it might be.
Would you like to address more concerns on that topic? Because otherwise I see it's more than 5:15, and if I understand right, at 5:30 we still want to hear what Mr. Zar has to say. Is that correct? So I would like to give the floor to the public, because I know from experience that 10 minutes is quite short. Unless no one has a question, please let me know. Do you have questions? Yes, there are. So I think we will start now. So I know from experience that this is a good part of the show. Can someone hand the microphone, please? Thank you. And please say your name and who the question is addressed to. And please don't make long remarks, but try to be specific with the question. Thank you in advance. Thank you.
Well, thank you for the occasion to speak with you. My name is Jesper Lundsmann. I'm actually here at the moment from the embassy, the German embassy in Luxembourg. And I would like to know, you said that there's no jurisprudence right now, and that there will be after, if this proposal is accepted. Do you mean that the decisions that would be taken by the tribunal to be instituted have an actually binding effect on the tribunal? Especially concerning the appeal body? Would the decisions of the appeal body have a binding effect on other cases? Thanks.
The question is for anyone.
Yes. Well, the establishment of an appeal system automatically establishes jurisprudence, because an appeal system cannot take different decisions on similar questions which would be conflicting, you see. So automatically by installing an appeal system, and that is one of the elements which is in the new text, will lead to jurisprudence. And ask all judges. They need jurisprudence in order to have a fair judgment. And that is exactly what is missing today, and that is one of the reasons why we would like to go in an intermediate step to this new system, the investment court system, and as a long-term goal to have an international court, which then would not be only for some continents, but it would be for the whole world.
Thank you.
Thank you. Anyone else a question? Please, sir. Please say who you are and if you may. Thank you.
I'm Diego Fernandez Arroyo from Sciences Po Paris. I would like to know, Madame Redden, if, for example, in the future, all negotiations with Mercosur are going on again, if the same principle will be taken into account for those countries. In particular, I'm talking about avoiding private justice, as you using your words, and going for a system of public justice.
Absolutely. I think that would be a precedent, and it will be followed by others. That's why it is so important that now in our agreement with Vietnam, we have already applied the new system. So that was a very strong, I think yesterday it happened, that is a very strong signal in order to say our future agreements will not have the old-style ISDS, even reformed like in CETA anymore. Now, I know that we would like to enhance our agreements, our negotiating with ASEAN and with Mercosur. Things are not advancing too well, but the political will is there in order to go very strongly. Why do we need to do that? We need to do that as long as the WTO is not functioning anymore as we would like it to function. It's very difficult for the time being to have WTO agreements, but we will try to have plurilateral agreements in order to have then later the possibilities to multilateralize them. That is also the way, for instance, how we are negotiating in the successor of GATS. We stay completely in the language of GATS, so that even if now a big part of the world will come to an agreement, the rest of the world can join it through the WTO system once multilateralization will be possible again. And that is one of the policies also which we try to obtain. We see bilateral agreements only as a method which is necessary now because of the stopping of the Doha round de facto. But it is not ideal. It's not what we would like to achieve. So we are in an intermediate step, and that is also why we have decided at a political level to have the plurilateral agreements to reconcentrate on the plurilateral agreements, Mercosur and ASEAN.
Does this answer your question? Yes. Okay, I saw a gentleman had another question.
Thank you. Alain Pella, you have my resume in the documents. J'ai une question pour Madame Weber. Malheureusement, je n'ai pas entendu votre présentation, mais j'ai entendu vos remarques. J'ai plutôt de la sympathie pour ce que vous dites ou représentez, mais je voudrais vous poser une question très brève. Montesanto, vous préférez qu'une cour américaine décide plutôt qu'un système tel qu'il est proposé par les Européens? Ça, c'est ma question pour vous. As far as Mrs. Reding is concerned, I will make an impertinent and rude remark. Listening to you, I have the impression that the US do not exist. That you think that whatever the Parliament can say, whatever the European Union can say, of course, there is no question we will not concede anything to the Americans. My view is more moderate, and probably we should already envisage what is really debatable, including, which is my favorite topic, including concerning the ISDS. I am not sure that just saying we want an appeal two-stage system, we want that and that, will be, as you said, they have a real problem with the International Court, and I wonder if we should not try to mitigate a bit our demands.
Who wants to start? Madame Reding, Madame Weber?
I can start if you want so. Well, I think I made it clear very often in my speech several times already.
Maybe
that
the introduction, yes.
No, also in some of the answers, that the fact that we put now on the table of the negotiation our blueprint in November, it means that in February the negotiations will start. And I said very clearly that I am not sure it will be an easy one. But if you start a negotiation from a feeble starting point, you will have a feeble result. So you never go into a negotiation from down, you always go to a negotiation from up. And you must be very sure about what you want to obtain. If you already negotiate things down, then you better don't start negotiations at all and leave things as they are.
Madame Weber, now, if you want to answer the first
Yes.
part of the question, which was...
Pour
yes.
moi, la question la plus importante, c'est d'abord qui peut légiférer avec quel droit. Et ça, c'est ça ce qui m'importe. Au début, on ne voulait même pas parler dans le public de l'ISDS parce qu'on s'est dit la question, c'est principalement qu'est-ce qui est à la base des décisions prises par les différents juges. Et pour moi, il importe que ce soit sans équivoque que les différents pays ont le droit de légiférer dans l'intérêt des intérêts publics, que ce soit clarifié sans ambiguïté. Et à nos yeux, ce n'est pas le cas. Pour nous, ça c'est la question principale. Et si on prend l'exemple des Saint-Jacques et des oysters, moi, honnêtement, je ne sais pas la valeur des différentes façons de mesurer la problématique, mais je sais, j'étais à une réunion du ministère de l'économie luxembourgeois la semaine passée où on parlait de la circular economy. Et la représentante du ministère de l'économie luxembourgeois a dit c'est le problème qu'il y a beaucoup de microplastiques. Je ne le savais pas, microplastiques dans les oysters. Si vous en mangez, vous mangez des microplastiques. Je ne le savais pas, honnêtement. Et pour moi, il m'importe que chaque pays ait le droit de suite de légiférer contre ces microplastiques sans qu'il doit avoir besoin d'un consensus au niveau européen avec les États-Unis et sans qu'il y ait la crainte qu'il soit porté sur une juridiction quelle que ce soit.
Si vous permettez, moi j'ai peur des microplastiques maintenant et de la Chine. Merci beaucoup. Est-ce que vous êtes satisfait de la réponse?
Non, pas du tout.
Pas du tout.
Est-ce que vous êtes...
La question était sur le règlement des différends, on me répond sur la législation. Donc ce n'est pas une réponse.
C'était une interprétation...
C'est la base de tout. C'est la base. C'est la base qui nous pose le plus de problèmes.
Et pourquoi est-ce que les nations légiféreraient mieux que l'Union européenne ou
vice-versa?
Pour moi, il m'importe que chacun ait le droit de légiférer. Moi, je vote les parlements, mes politiciens. Je vote pour mes politiciens et pour les responsables au niveau européen. Et pour moi, il m'importe que chaque citoyen, que ce soit de l'Union européenne, que ce soit des États-Unis, du Canada, puisse opter pour ses valeurs, moyennant ses politiciens, puisse faire la législation dont il a besoin.
J'aimerais céder la parole. I would like to give the floor now to Mr. President of the Institute here. You want to have a word?
Thank you. I would like to come back to the first part of this discussion and address transparency. I have the impression that the TTIP is negotiated in a very innovative way. The influence of the Parliament has been increased. The Commission is more under control. Maybe we have to ask to what extent public opinion has to be involved. My question is this the first model for a future way of negotiating conventions, agreements of such an importance? Should we continue that way? And I would be interested in listening to the different positions of our discussions here who are in different roles in the negotiations.
Is this a new model? Who wants to start? Perhaps Mr. Hübsch, you haven't.
Well, I think it's definitely the new model to follow, because in the public opinion there's no possibility whatsoever of any kind of U-turn in this regard. I mean, it's just not imaginable that for a next generation trade agreement that has similar effects than the TTIP has right now, or could have, that we could negotiate that behind closed doors. That's just impossible. I mean, we will have to follow the example that has been made now by the TTIP negotiations. That will also mean that our job now, as the people that are representing the member states in the Council, will have to cover new duties in that regard. That we have to do much more efforts in terms of public outreach. We have to go to the public and explain what we are doing, what are the benefits of it, what are our objectives, because at the end of the day, it will affect everybody's daily life to some extent or the other. So there's simply no going back to the old tradition, if you would like to call it like that, of just giving some pieces of information and saying for the rest that that's much too complicated to be explained. Leave it over to experts; they can deal with it. That's simply not feasible anymore.
Mr. Brown,
yeah,
please.
Just 2 or 3 words on this. The first thing is that the Commission for many years has pushed in the constitutional conventions and intergovernmental conferences for the European Parliament to get a full role in trade policy making, and this has happened since 2009. And I think with TTIP, but with other negotiations like TISA, we see the positive effects of that, and the positive effects of that is that trade policy is not being negotiated and discussed behind closed doors, but is being discussed in the Parliament and in public events like this. And it's important that it is discussed in those places so that the general public understand what we're trying to do. Specifically on your point, the answer is yes, and it's a very clear yes, because Commissioner Malmström has just had adopted by the Commission a strategy for her mandate as Trade Commissioner. There are many things in there. One of them is the Multilateral Investment Court, but another is that we would apply the same approach on transparency that has been taken for TTIP to all negotiations as they advance. So yes, this is the model, and this will continue this way.
Je crois qu'un des problèmes qu'il y a été dit bon nombre de fois cette soirée-ci, qu'on doit expliquer aux gens la valeur. OK, on doit donner des explications, mais on doit aussi se lancer dans des discussions sur des points très précis. Et moi, j'avais moi-même une réunion avec Mme Malmström aussi, vu qu'on a collecté les 3 millions de signatures. Et avec tout le respect, ce n'est pas une discussion. On explique aux gens qui ne comprennent pas. Et Mme Malmström m'a dit à plusieurs fois, les gens ne comprennent pas. Ceux qui sont contre sont polémiques ou sont seulement contre quelque chose et pas pour quelque chose. Moi, je suis pour beaucoup de choses, les relations avec la WTO, etc. Et que tout d'abord, on doit accepter qu'il y ait un échange réel d'égal à égal. Et pas qu'on dise, nous, on doit expliquer aux gens les bénéfices et après, c'est fini. Et deuxième point, si on dit qu'il y a les parlementaires européens peuvent aller consulter les dossiers clés à des points précis, durant des heures précises, sans iPhone, etc., pour qu'ils ne puissent pas faire des photos, etc., des documents, des heures précises, dans un local spécifique, dans un pays. Moi, je crois honnêtement que ce n'est pas si transparent que ça, et si c'est limité à certains parlementaires européens et non pas à beaucoup plus d'acteurs, je crains que ce n'est pas vraiment démocratique. Et troisième point, Mme Reding l'a dit elle-même, il y a seulement 20 000 personnes qui ont consulté ces documents. Il faut leur quand même se poser des questions, pourquoi c'est le cas. Ce sont des documents, je ne sais pas si vous avez essayé de les consulter, moi je l'ai fait, et moi je suis là je suis fière de moi, donnez-moi un texte juridique luxembourgeois, je vous le lis de suite, je n'ai pas de problème, mais des textes juridiques européens dans ce langage-là, je dois abandonner, je dois me fier à d'autres juristes ou d'acteurs auxquels je me fie. Comment un citoyen quelconque ou une organisation ou environnementale, même des syndicats, peuvent juger de ces 1000 pages de documents hautement techniques et hautement dans un langage juridique qu'on ne peut pas suivre même en tant que société civile. Et c'est ça le problème. Trois problèmes.
I think that was my second question I asked you actually about how is it possible to understand all these documents, but however, do you want to answer to the question of Mr. President?
Well, if you are hands-on as a member of parliament, you are supposed to read the documents. You can ask the same question to members of national parliaments. Are they doing their job? Are all doing their job? Okay, I leave it to this. Il y a eu deux éléments qui ont été une véritable césure pour répondre à votre question. Le premier a été le rejet par le Parlement européen de l'accord ACTA, où, devant l'étonnement du monde entier, on a vu que, oui, le pouvoir d'accepter ou de rejeter réside dans le Parlement européen. On ne le savait pas avant. Et puis, il fallait en fait le nouveau Parlement européen et la nouvelle Commission pour prendre un nouveau départ. Et ça a été fait en été l'année dernière, où franchement, le Parlement s'est donné les moyens d'avoir une voix qui soit entendue. Et pour qu'une voix soit entendue, il faut d'abord avoir accès à toutes les informations. Le Parlement a accès à ces informations et les parlementaires qui veulent avoir accès, ils l'ont. Donc, les parlementaires ont aussi la possibilité de se faire entourer par des experts, ce que moi, je fais régulièrement parce que je ne suis pas juriste. Je n'étais pas juriste d'ailleurs non plus quand j'étais commissaire à la justice. J'ai quand même réussi à produire 50 nouvelles législations qui sont maintenant appliquées dans les États membres. Donc, il ne faut pas nécessairement être juriste pour comprendre un texte, mais il faut prendre le temps de vouloir le lire, de vouloir le comprendre. Si on ne le comprend pas, de poser la question à ceux qui comprennent pourquoi la phrase a été faite de telle façon et à proposer des amendements parce qu'on trouve cette phrase pas bien. C'est ça, justement, le travail parlementaire. Il y a eu aussi un changement de cap très important avec l'arrivée de Mme Malmström en tant que commissaire européen responsable au commerce extérieur, parce qu'avant, c'était un peu la tour d'ivoire, à franchement dire. Mme Malmström a franchement décidé de faire la transparence. Et là où, malheureusement, je ne vois pas encore cette transparence fonctionner, c'est au niveau des États membres. Et je voudrais officiellement exclure le Luxembourg de ma liste, mais c'est au niveau des États membres qui, eux, font comme si de rien n'était et comme s'ils n'avaient pas de responsabilité. Or, la politique européenne est une politique commune. Et si je dis commune, il y a aussi la responsabilité des États membres, des gouvernements, d'expliquer. Je ne les entends pas, malheureusement. Ils n'ont peut-être pas encore compris qu'on est entré dans l'époque de l'Internet et que le top-down ne fonctionne plus comme il fonctionnait avant. Nous sommes aussi pour cette raison-là dans un autre état d'esprit et il faut aller vers les gens, il faut répondre à leurs questions. Moi, je suis, après mes 35 ans en politique, d'avis qu'il n'y a jamais une question idiote, il y a seulement des réponses idiotes.
Une dernière phrase que vous vouliez absolument dire, Madame Weber.
Oui, moi, je crois que ce n'est pas démocratique si le Parlement européen, les parlements nationaux n'ont que le droit de dire oui ou non. et de ne pas s'involver plus activement pour réaliser des changements, d'une part. Et je crains aussi, et je crois que le débat aujourd'hui, comme tous les débats sur le sujet le montrent, si on discute sur une directive, on discute sur celle-là pendant des mois, des années. Je crois que dans TTIP et CETA, il y a quand même le volume ou des décisions qui sont prises égalant 200-300 directives centrales qui nous influencent. De fait, je crois que ce n'est pas possible d'organiser un débat démocratique pour tant de questions clés dans un tel espace de temps, que c'est tout simplement pas possible.
Excusez-moi, tout simplement, je pensais quand même que maintenant, pendant 1h30, j'ai montré comment le Parlement européen exerce son influence. Et s'il y a ISDS dans une réforme maintenant mise sur la table, c'est bien parce que le Parlement a exercé avant de décider oui ou non, en finale, à exercer son pouvoir de contrôle de ce que fait le négociateur. Et ça aussi, c'est un élément complètement nouveau. Lisez la résolution de l'été et vous verrez qu'il y a un changement majeur qui s'est opéré. Non, le Parlement n'attend pas jusqu'à la fin, justement, et il exerce son contrôle de toutes les négociations qui se font. Et je dois dire, et ça aussi c'est nouveau, c'est une instruction qui a été donnée par Mme Malmström, que son négociateur vient chez les parlementaires qui s'occupent du dossier, répond à toutes leurs questions et donne un compte-rendu dans le détail de tout ce qui a été négocié et ce qui n'a pas pu être négocié. Et les parlementaires exercent leur pouvoir. Et c'est comme ça que ça doit se faire.
Ladies and gentlemen, thank you for being here as the guests of this roundtable. I'm going to stop now because I'm sorry, we are 10 minutes over, and I think Mr. Zar had to cut his speech now a little bit, or maybe you can go to 6:10. Should be fine. So I hope it was a good roundtable. Make of that what you will. Everybody watching you outside on the streaming, I hope it went well. And well, thank you for attention and thank you for coming here. Thank you. So, you can stay if you want. I'm going to sit here and contemplate.
Ladies and gentlemen, first of all, I would like to express Mr. Thielen's apologies for not making it tonight, because he's taken by another event. Actually, it is a great pleasure to be here with you tonight, and an honor to deliver after this interesting and insightful roundtable the closing remarks. In the past, we have tried together at the Chamber of Commerce as many interested stakeholders as possible to talk about TTIP. Entrepreneurs, ambassadors, parliamentarians, trade advisors, and last but not least, Ms. Christina Sevilla, Deputy Assistant to the Office of the USTR for Small Business and Market Access. They have all taken up our invitation to discuss the FTA, and in particular, its potential benefits for our SMEs, perfectly illustrated tonight by Mr. Hübsch's statement, and if you allow me, let's call it as of now, 2010-5 example. ISDS had so far not figured on our agenda. I am all the more delighted that Professor Dr. Ruiz, Fabri, and Professor Dr. Hess took up the initiative to organize this two-day conference on the probably most controversial element of TTIP. Thank you very much for this challenge. In my opinion, it is of utmost importance to protect our entrepreneurs abroad from any potential abuse or discrimination, especially our SMEs. Therefore, we welcome the EU Commission's statement in favor of ISDS and the proposal to modernize the current ISDS system, getting it more objective, transparent, and fair, like Mr. Brown pointed it out. The whole chamber network in Europe wants an ISDS system especially adapted to the needs of SMEs. Basically, we can apply the following logic. Our investors will not engage in any investment activities in a country where the legal protection is not provided. Okay, this statement might not be applicable for investments in the United States. But aren't we looking to set the golden standard with TTIP for coming FTAs? I could not have formulated it better than Ms. Reding did it with one world, one law, one court. By not opting for ISDS in an investment chapter in TTIP, we will miss the opportunity to increase our production, create new jobs and new wealth. The same reflection applies for foreign investors in our country. When they fear that their rights are not protected, we will not be able to attract them. In short, legal protection attracts investment and economic growth grounds on investment. We all agree that economic growth is key to job creation, healthy public finance, high-quality public infrastructure, the improvement of education and vocational training. The list is by no means exhaustive. Yet, in today's context of globalization and global supply chains, economic growth hinges strongly on a country's degree of economic openness. Let me capture it in a nutshell. If the third most open economy in the world, which exports 80% of its goods and services, and which has at its very roots in political and economic integration, turns its back on free trade, it will have to rethink its business model. I seriously do not think that this is an option for us at this stage. At this point, I would like to invite Ms. Weber to tour with me the country and to engage in discussions with entrepreneurs and to listen to their arguments in favor of open markets and in general and TTIP in particular, in order to better understand the direct value of both. Regarding the United States, I would like to remind you that they are currently setting the tone in the world economy. The world player China has dipped below 7% growth for the first time since the global crisis emerged. And a further slowdown is to be expected in the near future. Emerging markets, the shining stars of the aftermath of the crisis, are struggling, since commodities have sunk to their lowest prices since 1999, and trembling at the approaching increase of US interest rates. The US are rather doing well. Consumer spending stood at 3.2% in the third quarter, fueled by a dynamic job creation, and their unemployment rate has reached its pre-crisis level of 5%. Ladies and gentlemen, the US are clearly back on track after 15 years of watching China and emerging markets entering the world economic forerunners. Why wouldn't we want to set an ambitious framework for global trade rules in collaboration with the engine of global growth? Thank you for your attention, and I wish you tomorrow an inspiring and successful conference.
So this is there that we have received a lot of food for thought. And, I think it was a very interesting perspective from the Luxembourgish lens looking at the TTIP. We will go on tomorrow, of course, but in between we invite you for a reception which will take place
outside of this room here. Just join our collaborators and
go on discussing.
That's it.
Thank you very much.
Just
and
enjoy.
Thank you to our speakers for participating.